Can you hear us, Miss Elson? Mr. Driscoll, you keep popping in and out as far as your strength of your audio.
Can you hear me now?
Not very well.
I don't know why our audio, we had
There it's fine. Now it's fine.
It's all right now?
Now it's okay. Good.
Your Honor, the court made an announcement, the parties, like I said, the testimony we'd want to present is by the petitioner Rachel Ellison, and her objections to the journal entry that was submitted, and our objections pursuant to Rule 1 to the 170 journal entry. So we're ready to proceed whenever you are.
Okay. Miss Elson, you're going to have to unmute. And you need to raise your right hand. You solemnly swear and or affirm that you will tell the truth, the whole truth, and nothing but the truth, subject to the penalties for perjury in the state of Kansas.
Yes.
Are you currently in the state of Kansas?
Yes.
Thank you. You may put your hand down. Go ahead, Mr. Driscoll.
Rachel, can you hear me all right?
Yeah.
Okay. You recall that we had a hearing in September, and there was a journal entry prepared in connection with that hearing that was sent to us via Rule 170. Do you recall that?
Yes.
Welcome back, courtroom detectives. Today's case is one of those rare combinations that has everything: money, custody battles, and accusations that run so deep they could alter the entire future of one family. At the center, Rachel, an ex-wife, challenging not just her former husband's finances, but the very accuracy of the court's official
Objection that we filed on your behalf.
Yes.
I need to have you indicate to the court the purposes of this objection and why you feel that the journal entry does not accurately reflect that hearing that was held in September.
Now pause for a moment, because what Rachel says here is powerful. She's pointing.
First of all, the MFA eligibility, it was under my impression that he has 50-50 custody with his first wife. And so he only has the other children 50% of the time. He also, I don't remember the name for it, the parenting time adjustment, according to the state guidelines, says it needs to be at least 35%. And even with the holidays he pushed for, he has Anna less than 35% of the time. And let's see, the income, it's been the same thing year after year. We always get partial information on income. Like, here's his tax return showing that he has 3 different jobs, but let's only give pay stubs on some of these jobs. And like, I don't know how many times he's switching jobs or if he's currently employed by all 3, but it's always seems like it's just partial information. I also believe he might own a rental house because he lives at one address, he says, and he has another address in his name. When I pick up my daughter, his vehicles are all registered at the Rush County address, but I pick her up from the Ellis County address, and that the Rush County address is occupied.
Here's where it gets interesting. Rachel isn't just nitpicking the wording of a journal entry. She's alleging it paints a false picture of her ex's finances. These entries are supposed to be a mirror of what the judge ruled, not a creative rewrite. If the income calculations are off, so is the child support order, and that's not pocket change. We're talking about potentially thousands of dollars every single year.
Received your W-2 and sent it to me. Is that correct, ma'am?
Yeah.
For 2024.
The W-2s are now in play. Rachel's.
So he should have that. Greg says that he sent or is in the process going to send Mr. Hyatt's 2024 information. When we get that'd be forwarded on to you also. Do you have any other objections you want the court to be made aware of pursuant to this objection to the journal entry?
Not that I can think of at this time.
Okay. That's Mr. Schwartz. Do you want to inquire, or that's all the object? That's
That's the end of your questions, Mr. Driscoll.
I don't have any other questions.
It's a legal argument as to whether or not this is what you ordered. And if it is, we're done. If it's not, then the court probably needs to clarify what it did order. And I mean, I think the issue about his income is just arguing again what was argued at the hearing in September. I don't think she was happy with his income at that time, and that's where we're at. The multifamily adjustment, while she's right, he used to have shared custody. He doesn't anymore. He has residential custody, so that applies. And on the parenting time adjustment, I believe that's for summer months.
Rachel's testimony reveals her frustration. Every year she receives partial income records from her ex-tax returns with missing pay stubs, job histories that seem to evaporate, and now a mysterious second address. She suspects a rental property generating unreported income, a red flag in any child support case.
You have no questions for her?
Let me double check, but I don't think so, Judge. No, I don't have any questions.
Ms. Grabby, do you have any questions?
No, I don't have any questions, Your Honor.
Okay.
Are we going to have the opportunity to make do you want me to make a statement now or?
Well, Mr. Driscoll, the purpose of the objection is to show that the journal entry does not reflect the court findings. Do you have any evidence regarding the court findings?
I don't have a transcript or anything to show what the court's findings were at that time. It's supposed to accurately reflect the respondent's income, which we disagree with, and the other, the multifamily eligibility and eligibility of parenting time adjustment either was not addressed and I don't have a transcript of those proceedings, so it's hard for me to say one way or the other, Judge. And my memory's not that good to go back to September, so I can tell you that.
Good.
Here's the core of Driscoll's argument.
The W-2s come into play, and this is where timing matters. Rachel has already turned over her 2024 income records, but her ex hasn't. That gap isn't just inconvenient, it could be decisive. If his new W-2 shows higher income than what was used for the journal entry, it's almost like building a house on sand. The entire child support calculation becomes unstable.
Yeah, court file, I can give the court the case number on it, but it's the court could take judicial notice of it. It's a Rush County case, but he has residential custody of the children in that case. He didn't previously, but he does now. As far as the parenting time adjustment, the mediated parenting plan that the court addressed said that for summer break for 2023, it set out specific dates, but then goes on to say that after that, the party shall have alternating weekly parenting time. And under the guidelines, if you have 50% or more of the time or a shared arrangement in any 30-day period, you're entitled to 50% reduction for that month, and that's what that adjustment is for. So I think that applies. And then on the income, these are the same arguments we had at the hearing, and the court made its ruling.
Ms. Grabby.
Thank you, Your Honor. Yeah, I believe the issue we're here on today is whether or not the orders reflect what you ordered at the hearing. And when I review my notes, I do believe, as Greg says, that the orders do reflect what you ordered at the hearing for income. When I reviewed this for the MFA and the parenting time, I find the same thing that Greg found. So I feel like the orders that were submitted via the Rule 170 are reflective of what you ordered at the time. And that's our position. I don't see anything else that's different.
Ms. Ellison, did you have a question?
I'm just wondering if there's a way that I am able to see this Rush County case that shows that he now has primary custody of these children, because last I was given any information, he was pending aggravated child endangerment with one of those children. And I just really, it's just hard to believe, kind of like the income thing.
Now listen carefully to Mr. Schwartz, the ex-husband's attorney. He's essentially saying, this isn't about relitigating income. It's about whether the journal entry accurately reflects the judge's ruling. But here's the twist. With no transcript, nobody has an official record to lean on. It's like trying to replay a championship game when the cameras were off.
That the parties were to use the multi-family calculator on the child support. He was not getting credit for parenting time adjustment. And the parties were to exchange their 2023 income and 2024 income
We have yet to receive that.
when they have that completed. Okay. So the journal entry appears to reflect that. There are 3 attached worksheets to that journal entry. That appeared to reflect that. Do you see anything